What was the start at 3 o'clock?
Sure, sir.
All right.
Yes.
Hello, everyone. Thank you so much for joining us today's session on patent due diligence for startups and MSMEs. I am Dr. Himak Shah. I work for Qualcomm and I'm also the co-chairman of the National IPR Council at ASSOCHAM. Now, in today's webinar, we have two amazing speakers. I'd like to introduce you to them. After that, I'll cover what L2 Pro is, and then we'll turn it over to the speakers. So today, to discuss this important topic of patent due diligence, and before we dive further, it's really important that anytime you're considering the kind of IP assets that you want, you perform, a thorough level of analysis so that you know what you're getting. These are at the end of the day assets, and you want to know for sure, you need to have a strategic vision with regards to how they play an important part in your business strategy. I apologize if you're hearing some background noise at my end. I'll try to minimize this. But our first speaker for today is Vijay Chirpuje. I know Vijay for a number of years. He's a very passionate IPR teacher. Like he's conducted hundreds of workshops. Formally, his affiliations are that he's the director of Patlex Business Studies, and he's also the CEO of EduLiteracy. He is an IPR advisor at IPFC Amsterdam, a mentor of change with the Niti Aayog's Atal Tinkering Labs, and a mentor at Startup India. Now, Vijay is very actively also training a number of patent agents, and he has an amazing success record. And the part which I love about him is he brings wonderful means into how he teaches IPR. So, thanks, Vijay. Thank you for joining us today. We are also joined by Dr. Pankaj Kumar. Dr. Kumar is IIT IPR Chair Professor at NLU Social Academy in Assam. He has held, doctorate in biotechnological patents, a master's in law, and advanced master's program in information science, a PG diploma in IPR. He's a registered patent and design agent, advocate, trademark attorney, IPR facilitator, and AICPE innovation ambassador. Dr. Pankaj has been working in IPR since 2005, where he had joined the IP unit of CSI headquarters in New Delhi. An amazing record that he has served by filing more than 500 IPR applications. So, Dr. Pankaj, thanks so much for joining us here today. Now, today's program is brought to you by L2 Pro, and L2 Pro is an IPR initiative which stands to protect, secure, and maximize your innovation.
Himang, so sorry to interrupt. There is a little disturbance in the voice. It's
Sir.
a bit muffled.
Yes, sir. It is echoing.
So, Kirti, I think there's some work around where I am. So, why don't we do this thing? I'll cover L2 Pro at the end, and why don't we instead hear from Vijay? Vijay, that is okay.
Sorry, sir, your voice is not clear at all.
I think what Kirti, what he's suggesting is we should move ahead with the presentation, and later on he would cover it.
Okay, sir. Sure.
Yeah.
Thank you.
So Parul, can I take it ahead?
Sure, sir. You go ahead.
Yes, sir,
Platform
please
is
go
yours,
ahead.
sir.
Thank you so much. Thanks, Parul, Kirti, the IPFC ASSOCHAM team, and thank you so much, Himang, as well, for the warm introduction and the L2 Pro platform for giving me this opportunity to present here. This is rather a second opportunity for me on the L2 platform. It was long back, almost a year back, I would say. I had presented about the patent registration process, and as an individual or as a professional working in the life sciences industry, what has worked well for me in last 1 year is there have been, I would say, a lot of changes that are happening at the IP system front as such in India. And as well as a professional, we have been working, I would say, extensively nowadays, that it's adding a lot of value for our knowledge as well. And I think L2 Pro works as that knowledge sharing platform for everyone as such. And, and I would say I'll be sharing few of the insights that we have learned over last few years, especially in the context of patent due diligence as such. Just one request, Parul and Kirti, if you can mute people, I can see in between there are people who are unmuted.
Sure, sir. Sure, we will do that.
Yep, thank you. Okay. I'm going to discuss on patent due diligence from my perspective as an agent, or I would say as a practitioner. And since, as I said, we have been practicing specifically in the life sciences industry, I also understand that although the presentation is precisely for the startups and MSMEs, I'll also try to cover it in a very broader perspective with respect to the incubation centers or the IICs or the universities, educational institutions, because these have been the hubs for the startups and the new generation entrepreneurs as well as MSMEs as such. So to start with, let me share my screen. Okay. Can you confirm if you can see my screen? Yes, thank you. Okay. So I've been told to speak about patent due diligence, and the time frame that has been allotted to me is almost 30 to 40 minutes. And I understand, most of the participants are also more from the research side or technical side, and understanding uh, the patent system, or I would say the business aspect of research is something which is significant when we speak of a MSME or startup as such. So at the end, I remember one of the very famous quotes in one of the sessions that I had heard was whatever research you are doing in your lab, whatever I would say publication you get, or whatever number of research papers you get, whatever is the impact factor for that, at the end of the day, the research has a zero value if it doesn't have any benefit for the society, basically. And we have been seeing this, that so much of research is happening in terms of numbers, but then what is significant or what is important is that your research, whatever you do, basically has to be commercialized, has to be for the benefit of the society or the people as such. That's why I think government is also putting so much efforts into the research activities or R&D activities as such. In fact, as a practitioner, a lot of times what we are getting is the request key, we have we, we have got patents granted and now we want to commercialize it, basically. Now, this is one myth, that if you have a patent granted, you can commercialize it, basically. Because as such, as a concept, patents are what we generally call it as more or less like a negative right, which excludes everyone else, except you or without your permission to use that particular invention. And that's how most of the IP works, basically. But then, where are we lagging as a economy or as a country, or maybe I would say, specifically in the MSME domain, basically? There may be a lot of research happening as such, to certain extent from the academic institutions to even the corporate side or the MSME side. But then the proper due diligence, and when I say due diligence, it is not with respect to only patent due diligence, but the market due diligence or competition mapping. And that's how I would put very broadly as a due diligence. It may involve your market due diligence, whether the research that you are doing, does it really have a value or is it really worth to be commercialized? If whatever product you are developing as a MSME or as a startup, is it really sellable? Because you may have a great invention, but then if it doesn't have a market value, then probably we are kind of wasting the energy in that particular startup, in that particular MSME or research, right? Now, so that's what we call as market due diligence. And if you look at the kind of research is that is happening herein, the focus has always been with respect to the research paper or the novelty. We generally do not take care of that market thing or market due diligence. Is your research really needed basically? That is I would say one thing that is crucial as far as the startups or MSMEs is concerned. Second important is competition mapping as well. We do literature survey, we do literature search as such, but then when I say competition mapping, it's just not about what products are already marketed, but who are the other competitors who are also in the development pipeline basically for that particular research, because or for that particular product, be it a startup, be it a small unit, or be it any research institute as such. There is a high probability that you get inspired from some articles or some ideas basically, and based on that we are focusing or we are giving the direction to our research as well. But then at the same time there can be replicas as well, or other people working on the similar stuff or similar startup idea or similar product idea or similar process idea basically, right? So competition mapping is not just about who is selling the product, but who is preparing to sell as well. That is important in terms of I would say the diligence as such, because that would give you a lot of insights, not only from the IP perspective, competition perspective, but also from the business perspective. Because at the end, for me as a patent practitioner, the real value is not, I would say, just getting the patent granted, but the real value would be something which I would say is more about making sure that the product is successfully launched as well as commercialized as well. That's where the real value is, because otherwise we are filing patents kind of, it's a routine as a firm for us. We file patent, we get it prosecuted, we get it granted, वो renew होता रहता है, and at the end we are just doing the formalities with respect to the patents, but then they are not commercialized. And lastly comes the concept of patent due diligence, I would say. Beyond market due diligence, competition mapping, patent due diligence. And that's the topic that has been chosen. Honestly speaking, there can be an entire full workshop, or I would say a kind of a course as well on patent due diligence. It's such a broad concept. But what I'm trying to do here is based on the needs of our everyone, all the participants, and presuming they are from startups, they are from MSMEs, as well as they are also from universities, the IICs, incubation centers. What I have done is I've tried to split it in very simple two parts. One, when we think of patent due diligence, it is about the patentability aspect. The other is the freedom to operate aspect. What do we mean by this? And generally, when we think of patent due diligence, uh, the focus has always been on the patentability aspect, because uh, patent sells really well. Now what do I mean by that? Actually, so if you have a patent, the patent doesn't get sold, but what I mean to say herein is that if you have a patent, then there is a suddenly a brand value associated with that innovation or the invention basically. And that's where the entire focus has been as far as the patent due diligence is concerned, on the patentability aspect. What you are doing as a MSME, what you are doing as a professor, what you are doing as a researcher or what you are doing as a startup, is it patentable or not? And this has been discussed in so many forums. We know the basics nowadays about the patentability as such. But then from a due diligence perspective, I would say the first aspect is about the patentability, whether you can get a patent or not. Of course, we have specific criteria. These have been generally discussed. Now it's part of the syllabus as well in many universities, or it is also part of L2 Pro as well. If you go through that, a lot of things of these are included in the L2 Pro module as such. If you want to know the details, you can go through that. But now, what I'm going to discuss more from the due diligence perspective is also about the other stuff, where like who can file basically the patent. Now generally the questions are as simple as that. For example, if there is a startup and they have to file a patent, who is eligible to file basically? Is it the Can we file in the name of the startup? And do we need a startup registration certificate for that? Do I have to wait for that? Or I can file in my name and later on transfer the rights to the startup? Now, who can file is the most crucial and important, I would say, due diligence that you need to do while filing the patents. Now, who can file is not what you decide as a startup, that okay, I have got these I am filing in the name of a startup, and these are 4 or 5 employees I have. These are the ones who are actually working on the project, and they should be included as inventors. The concept who can file, of course these are coming from Indian Patent Act. Who can file, in that inventor is a very specific concept, wherein we have to ensure that only those people who are involved into two things are included as inventors. First set of people, those who were involved as for the conceptualization of the idea, those who conceptualize the idea for that particular product or a process basically. Now, when I say that, it can be from anyone actually. It is not necessary that it has to be from I would say only someone who is the highest in the hierarchy basically. Beyond that, the second set of people who can be included as inventors basically are the ones who executed the idea, who help executing the idea, knowing what they are doing. Now, why I'm saying knowing what they are doing, when we are working in a lab setup, we may have lab attendant or other people as well who are kind of helping us to execute the experiment. But are they the inventors? No, they don't know what they are doing basically, right? Or for example, if I am in a lab and my 4-year-old daughter also is there, and she says, Papa, I helped you when you were carrying the experiment, and I helped you with respect to that as well. Is she an inventor? No. Those who are involved into execution of the idea and are they do know what they are doing, what is the outcome they are expecting. Okay, that's how the concept of inventor works. Also, there is a myth actually about the assignee actually, and many times unfortunately the experience has been that the MSMEs of startup, they're not in a position to understand the difference between assignee and an inventor. They're happy if they're one of the startup co-founders name is there as an inventor. Sorry, there are no legal rights associated with inventor. The inventors do not have any legal rights with respect to the invention. All the rights are with the applicant or assignee, unless there is a separate agreement between assignee and inventor. This agreement is executed. Only in that case the inventors may have certain rights. Otherwise, there are no specific rights for the inventors as such. Legal rights I am speaking, be it for licensing it out, be it for selling it out, be it with respect to anything for that particular invention basically, or commercialization for that sake. Where to file is easy when we have got the four patent offices. Nowadays it's a e-filing, so you don't need to worry much about where to file. The system automatically takes it actually. With respect to jurisdiction,
Hmm.
वो डॉक्यूमेंट सेट किया था मेल किया था
Hmm. बस ऐसे
uh,
ही।
लेना
Kirti, like a lot of
Please mute if you're
background
not
noise.
speaking. Thank you.
Malkit Kaur, can you mute yourself, please? Yep, thank you. Okay. Where to file, as I said, becomes complex in a kind of, I would say, collaborative research, or when you are working with, there are multiple parties. But then the answer generally to this is the first applicant decides where to file, the jurisdiction basically. Otherwise, we have east, west, south, north, and the patent office has specifically provided that jurisdiction answer. But then this was helpful long back when we had physical filing, and nowadays since we don't have much to do with the jurisdiction, because generally what happens is if you are filing a case in Mumbai patent office, it need not necessarily be prosecuted in the Mumbai patent office. Rather, it may happen that it gets prosecuted at other offices as such. Rather, the practice is that the Mumbai applications are prosecuted at Chennai, Kolkata, Delhi, and vice versa as such. Now, when we think of due diligence from a startup or MSME perspective, how to file, of course, any patent agent can help you with that. But then I have some specific observation here, and this would be very much applicable to all the universities and the I would say the technical people as well. See, I come from life sciences domain. I come from pharmaceuticals. I understand chemistry. I understand biotech. I understand Nutra. I understand, I would say, certain specific sector, healthcare, biomedical engineering, I understand. But then, while drafting a complete specification or a patent application, it is very essential that your patent agent should understand your invention first. That's what I generally tell, that if you are from a specific sector, try to get an agent or attorney from your domain, which will give you lot of help while drafting as well as prosecuting that particular application as well. That is something which is very crucial and essential, because these are the things. What happens is I also get lot of inventions from technology domain or engineering domain. Many times I am not able to understand the invention, so I may not be in a position to make a justice to the invention, not only with respect to filing but during prosecution as well. So it is very essential that the expert or agent with which who is representing you firstly understand your invention. Just do not go with the big names, or I would say just do not go with the pricing only, but try to evaluate it in an unbiased view, whether the agent or attorney is able to understand your invention, right? Now that's I would say something as a part of a due diligence you should do before filing the, or drafting the patent application. uh, there are a lot of I would say a lot of things with respect to the types of application, when to file a provisional, complete. There is a concept called as divisional applications. There is also a concept called as patent of edition, how to utilize that as a strategy. See, when we think of research or commercialization, or as a startup or MSME, uh, we don't stop the research. We always try to improvise on our products, basically. So you are, so you can call it as a version 1, 2, 3, 4, 5. Now, version 2 may not be patentable over version 1, because it's already in the public domain. That point of time you can explore uh, options like I would say the patent of edition, basically. Or if you come up with some minor modifications, that point of time you can get benefited by the concept called patent of edition as such. So there are a lot of things with respect to type of patent application which need to be evaluated in an effective manner before you file a patent as such. Now this is how the entire ecosystem is working. for the startups and MSMEs, or for universities, or even for that sake for the corporates as such, it is very essential that you have to understand these basics about patentability, basics about who can file, where to file, how to file, and what type of application is suitable for me before actually going for patent filing. Now, on a flip side, I would say that, so this is one part which has been discussed. I would say very widely in all forums, and as I said, if you are actually innovative, you have research, uh, you can actually, like, be going through these processes as well, for sure. But I think more important from a startup perspective or MSME perspective is the second part, which is freedom to operate. I also run a startup which is into edutech domain as such. Now, what is important for any businessman or a startup or a MSME is just not protecting it. At the end of the day, I should be in a position to commercialize my product. I should be in a position to utilize that invention and sell the product in the market. And that's where comes the concept of freedom to operate. It's absolutely fine. It is not necessary that every startup, most of the startups which are from aggregator domain, they may not be in a position to come up with inventions. Or most of the MSMEs which are into manufacturing sector, which are into small scale manufacturing, or loan licensing kind of manufacturing, therein there may not be inventions, but from patent perspective or due diligence perspective, for them it is very essential to understand that what product they are developing or what processes they are following actually to prepare a product. These are not using third party IP. That means if I launch my product, it is infringing, what we call it as enroachment in case of property. Mera property है, someone else uses it without my permission, I call it enroachment. Third party का patent है and I use it without the permission, that's what we call infringement basically. So infringement is something, and so the term here is freedom to operate. Am I free to use my invention or commercialize my product in the market? That point of time, as a startup or MSME, again, this is more related to commercialization. So when a university or an academic setup or a IIC thinks of commercializing, that point of time, we may have these things need to be evaluated. Rather, while working with one of the incubator based in Western India, we got more requests for FTO than patentability as such. The reason being that uh, the maybe, as I said, the startups know on their own that, like, many times we get these requests, sir, we are the first one in India. This kind of product is available in Russia or US or UK or Canada or Australia. I got inspired by this idea in Singapore and I want to implement it here in India. Absolutely fine, perfect from a business perspective. But is it novel? No, you may not get a patent for that. That is also absolutely fine. But the most crucial or important thing is, if you want to launch that here in India, please launch the product here in India. Am I free to operate? Can I launch the product? Is there any third party who has the patent for that? That that need to be something which have to be evaluated. I would say as a uh, part of a due diligence. And freedom to operate generally requires two kinds of expertise. One is technical expertise. I have to understand your product first, as well as secondly is about the patenting, or I would say the legal expertise as well. Now, most of the people get confused between FTO and patentability. Patentability, as I said, is about whether my product can get a patent for it or not. Can my product get a patent or not? If the answer is yes, the evaluation itself is patentability evaluation. If the answer is yes, you can get a patent for that. But if the if you want to commercialize or launch, therein you have to evaluate freedom to operate, and that's what we call as infringement. And infringement analysis is very different from patentability analysis actually, because infringement analysis involves all it just involve it is jurisdictional specific. It is more about understanding what patents are filed, at what stage are they enforceable, who has got these patents, who has the legal rights for that particular patent as such. And again, infringement analysis is something which is at most of the times done internally by the big MNCs as such. So throughout my career for 12 years working with MNCs, we used to do infringement analysis or FTO analysis internally basically. That's how the infringement part works. But then there is one slide which would give you lot of headache, I would say. But the moment you understand the entire patent system, you can understand this slide really well, I would say. The first part, and the I would say, I have got this kind of quadrangle, four different type of things as such. First part is, if my product is non-infringing, can it be patentable? Yes, non-infringing and patentable, everyone would agree on that. Second part, infringing hai, my product is, I cannot launch because someone else has a patent, so I won't get a patent, my product is infringing. These diagonal things are very easily understandable as such. But now let us come to the other two things as such: infringing and patentable. Now, what do I mean by infringing and patentable? Basically, I can get a patent for sure for the invention, but I cannot launch my product. Let me repeat. I can get a patent for my invention, but I cannot launch my product because there is another patent which is broad enough that I cannot launch my. Then how did I get patent? So the patent system works on a principle, and there is a concept called genus species, that out of 1,000 things, if you pick one and show that this one thing has lot of advantages, you can get a patent for that. So you can get your invention patentable, but unless the third party patent gets expired, you cannot launch your product. So that's why we call it as infringing and patentable. The fourth aspect is easy to understand. The only complex aspect in this quadrangle is the infringing and patentable. But the more, so as I said, this is more technical, techno legal. The moment, I would say, you understand the entire patent system, patentability, and the infringement, as I said, these are completely different. That point of time, probably you would be in a position to understand it. The last part is non-infringing and non-patentable, because किसी ने patent file ही नहीं किया है, तो मुझे भी नहीं मिलेगा, but then disclosure है, इसलिए non-infringing है. So my product is non-infringing and non-patentable. I'll give you an example. I think that's what someone has requested actually. And let me give you an example from my industry, the life sciences industry as well. This is for infringing and patentable, and I think I would just need 2 or 3 more minutes with this example, and then I can conclude with my session as such. So I'm working on a drug which is used for the treatment of diabetes mellitus. The drug is patented already. The drug itself is patented already. I come up with a new technology to administer that drug by oral route. I come up with a technology to administer the drug by oral route. Now, I can get a patent for oral administration of the drug, but still I cannot launch the drug unless the patent for that drug is expired. So this is how the infringing and patentable thing works. As I said, a bit complex to understand, but it would require, I would say, a deeper understanding of this particular slide. This particular slide of infringement versus patentability. If you understand this, then probably this part would be something. And again, typically for a startup or a MSME, they have this myth that mere paas patent hai, I have a patent, that means I can launch a product. No, that's absolute myth. That's absolutely wrong. Getting a patent is a different thing than launching a product. If you have a patent, you can block others from using your invention basically, but then it doesn't give you any right to commercialize your invention as such. So I would just come to the conclusion of this particular presentation. I have got 35 to 40 minutes time allotted to me. I've tried to do justice to that. To summarize what I have discussed is, to summarize what I have tried to discuss is, from the due diligence perspective, two separate activities. One, for sure, and the most important, and uh, generally that has been discussed again and again in multiple forums, and most of us have more clarity on that, which is about patentability, whether a startup can or MSME can get a patent for their invention or activities. If that is just one part of the story, I would say, as far as patent due diligence is concerned, the second important and complex part. Okay, and I'll tell you, I can have lot of case studies for patentability, but why can't I have case studies for more for the infringement part? The reason being that, again, most of the startups are or MSMEs are happy once they get the patent, like, and many a times we are seeing actually that the products are not commercializable. They are not commercialized as such. So that is that, and therein there is no question of FTO then basically, because in many cases, may it be because of the market conditions, may it be because of the like, lot of other parameters, the products are not seeing the day of light. And in fact, I would say, uh, a harsh reality on ground is that we got 48 patents granted till date from our very small firm, I would say. But then just one of the invention is just commercialized. Again, that since it is coming from an MSME basically. So once we move as an economy, as an industry, as a country, from this invention to commercialization, lab to market जिसे बोल रहे हैं, and that's what is the focus for the I would say most of the policies nowadays as well. That point of time, we also need to deep dive into the second aspect of freedom to operate that I tried to discuss in last 15 or 20 minutes. Thank you so much once again. Thank you so much, Himang. Thanks, Parul and Kirti, for having me here. And I would be happy if there are any specific questions.
Thanks so much, Vijay. Indeed, as always, it's a very insightful and a very practical session. I mean, the way you outline the different workflows, I mean, truly, and you can see in the chat box also, a lot of people have found this useful. And for the folks who are asking for the recording, yeah, and sometime please check the L2 Pro YouTube channel where Parul and Kirti and team have been very diligently posting all these sessions over there. Now, in the interest of time, let me bring up Dr. Pankaj Kumar. And Vijay, if it is possible for you to answer over the chat, maybe you can. But I understand you have a hard cutoff.
Yeah, but I'll be available for next 10-15 minutes, and I'll try to answer some of the questions
Sure.
if there
Thanks
are.
so much.
Thank you. Yeah.
Dr. Pankaj, over to you.
Sir, kindly unmute yourself. Your voice is not audible. Dr. Pankaj.
Thank you.
Dr. Pankaj,
I
we cannot hear you.
anticipated,
Hi, yeah, now I can hear you.
I anticipated from Vijayji, he must focus on patentability and FTO because I know him and he is very active in filing patent applications. And I'm surprised he disclosed how many applications so far granted, and there is hardly much applications which are commercialized. And this is the ground reality. And that's why we need due diligence in patent. Because only filing may not serve the purpose, we must realize the ground realities about challenges in commercializing and what tips we must use during the filing and prosecution of such patent. So I will skip some slides. So everyone aware that such inventions and innovations changing our lives, and there are so many fields in which we see there are so much innovations. These are some successful case studies or some example you see. An idea can change your life. So inventor licensed the system to Coca-Cola 1/10 of a penny per can, and during the period of validity of the patent, the inventor obtained, see the amount, a day on royalties. This is per day commercial gain. As per European Union IP Office, firms that own intellectual property rights have an average 20% higher revenue per employee than firms that don't. And that's why nowadays this is a trend of maintaining IP portfolio. So innovations to a startup. As Shipuje sir already said, lab to market. Similarly, in order to create or invent, we need time, energy, efforts, isn't it? So we must be recognized and get incentive by monetization. And so we may get paid every time if someone interested reproduce our innovations. And that's why we need legal protection. And IPR is a tool to protect it legally. So it helps in Atmanirbhar Bharat. And further, it helps to have a competitive edge. We may differentiate from others. So there are so many benefits. We must respect IPR of others. So there is a legal right in research and development work. It provides market entry barrier and competitive advantage. And that's why it's exclusive in nature. The person interested need prior authorization. There are so many startups nowadays based on such IP. If such IP tool is not provided, they hardly succeed in their innovative businesses. And that's why there is a FDI, there is increased investment in research and development. There are so many R&D joint ventures, partnership with industries, strengthen innovation and entrepreneur system, improve national and international ranking. Many times IP portfolio help in ranking, not only startups and commercial entities, but the academic institutions nowadays also. And that's why everyone is focusing on IP portfolio. So these are the main objective behind IP protection, to exclude other and to utilize it for commercial purposes. So this is the life cycle. We must remember such protection is territorial. And that's why we need to find the market where we need such type of protection. And we can get protection country-wise. Although they are a system of international application, but there is no any international patent or global patent or world patent. We have to enter nationally. We have PCT arrangement. so that we can file international application that can be treated like a provisional application, but in order to complete, we have to enter in national phase. So under the life cycle, it starts from idea. So ideation to creation, we have to express our idea so that something can be created. If it is useful, inventive, and novel, then we may go for protection. Once we get such registration, we have to maintain it by renewing time to time. Otherwise, such grant may lapse. So there is no any benefit of such registration. If there is a market, if there is a demand, we must enforce our patent by renewing it. And commercialization, it's depend on the patentee, the right holder, whether he exclusively using the invention, patented invention, or may commercialize it by licensing to someone else or by means of assignment. So there are options to commercialize such type of patented invention. And we also make a due diligence whether someone using it unauthorized way, so that we can enforce our patented rights. So there are some steps. Most of we people, I hope, aware about such steps. So we have to keep in mind that we have options of provisional filing so that we may get 12 months time to complete it. First come, first serve basis. If we wait for complete application without filing provisional, maybe someone else apply such inventions earlier to the person interested. And we can avoid non-disclosure agreement if we are in position to file same day the provisional application, so that we have still time to complete it. There are several documents, no need to worry, your patent agent will take care. Although any person can file their application their own, but it is not recommended. So there are certain forms, these are minimum documentation which needed in order to file your applications. At the time of filing, we need Form 1, Form 2, and power of attorney. We need to submit proof of right, if applicable. Form 3 for foreign filing details. Request for publication, that is optional. If we need early disposal of our application, then we may go for early publication. Otherwise, by default, it will be published after expiry of 18 months from the date of filing or the priority, whichever is earlier. So this is an optional step, publication. Request for examination, this is not optional, this is a compulsory. If we wish to dispose our application, we have to request for examination. And after the examination, there is an office section. Generally, we say examination report or first examination report and second examination report, so on. So there is a 6-month time from the date of issuance of such examination report. We have to reply within this prescribed time. There may be opposition. Opposition is of two types, pre-grant and post-grant. Nowadays, patent office is little restrict over such oppositions, so that no any frivolous opposition can be considered, and controller have power to consider whether such opposition may be taken or may be considered or not. Or disposal. Disposal may be by means of grant or by means of refusal based on the ground.
Was it mentioned earlier in any of the forms?
If you're not speaking, please mute yourself. Yeah, sorry, Pankaj, please go ahead.
Whenever we have some idea, an idea can change your life, a commercial idea, an idea which we think can be patentable. So see, first, we can't protect idea. We can't stop anyone else. No, this is our idea. How can you think about my idea? So we have to protect our innovations, our creations, which is the expression of the idea. So we have to express our idea in some tangible form. So if we disclose such idea, such information, such knowledge to anyone, it is risky. Because if it comes in free public domain, there is a problem of fulfilling the criteria, first criteria, particularly the novelty. And that's why it is suggested that before discussing with someone, we have non-disclosure agreement. But I suggest do some groundwork and prefer filing a provisional application so that we have a pressure to complete it as soon as possible and lastly within 12 months. So these are some common mistakes. Most of the times inventors are so excited, they're publishing such a invention disclosure on some bloggings or on some websites, their own institutional websites, startup websites, and use of invention in public, they start commercialization before protection. So it again create a problem. Any person interested can copy it, and it's very difficult to stop them if we didn't protected it in time. So wait until the invention is fully developed for commercial working. Many times, some people thinking that it may not be fully developed so far, so we need to have work further and taking time. So again, there is a risk of disclosing such information, or maybe someone having same or similar kind of inventions. CSIR ex-director Dr. R.A. Maselkar earlier said their staff scientists publish and perish, patent and prosper. Because there is a culture of publication in the scientists, they publish their research work in journals, and so they get recognition, but there is hardly any monetization there. So publish and perish, they can't stop anyone. No, this is our invention, you can't use it without our prior permission, no. So patent and prosper. If we get it patent, we have both benefits, benefits of recognition and benefits of prosperity by monetization. And further, we are free to publish it after filing the patent application. So it serves both the purpose. So patent protection is particularly useful for costly to invent, but cheap to imitate such ideas. So what if we don't protect our inventions? So we lose our competitor, we lose to duplicates, we lose to importers, lose further exports, because these are the rights. And if we don't have such exclusive rights, we lose the market. So there is the option of trade secrets. Either it depends on the kind of inventions, whether we can protect it by means of trade secret rather than going for patenting. So we have to check whether it may be considered for trade secrets or patent is essential for such kind of inventions. So in both way, whether it's for patent or whether for its trade secrets, in both way, we have to sign the agreement if we needed to disclose such information to any person, if it's a patent agent or any experts. So I'm skipping some slides, although these are important. Contents of NDA. So these are some of the rights of patent, and see the difference in patent versus trade secrets. Under patent, we have 20 years of protection from the date of filing or the priority, whichever is earlier. But in case of trade secrets, it depends. The time which we may maintain to protect it. So a scope for publication of development, we can publish the patent applications, we can get recognition, but no such opportunities in trade secrets. We can enforce our patent rights by infringement suits, but in case of trade secrets, we can cover it under contract clause. So there is a breach of confidence if we sign the non-disclosure agreement. So this is a fiduciary duty to enforce such contract clause. Under patent, protection can be broadened beyond a specific discovery and development, but protection is very specific for particular secret. That is a confidential information. So why we need to transfer a technology? So scaling up the technology to industrial level and bringing it to the market could be very challenging for the technology developer. And that's why many times we heard about technology transfer by means of either assignment or by means of licensing. So there are options of joint ventures. Further, license can be an exclusive license or there is a non-exclusive license. Exclusive license is just like an assignment, but there is no transfer of ownership. In assignment, there is a transfer of ownership. But in exclusive license, the licensee enjoy just like assignment because there is no any other competitor, no one else having such a license. But in non-exclusive license, there may be multiple licensing. So we must remember some of such points that first protect, then publish. We can publish even after protection, that is filing the patent application, but we can't get patent rights after the publication. In fact, patent office publishing our invention twice, at pre-grant publication and post-grant publication. And we are free to publish it after the application. Rights are territorial. Further, we need to keep it in mind that these are territorial in nature. So we have to find such countries where we can enforce our such rights. There is a market, so we can go for international filing. Registration is done by sovereign authority, country-wise, the government. Priority, if any, if there is a priority, we have to claim it, and it is advantageous also. The time will reduce because it will be count from the date of filing or the priority, whichever is earlier. If there is a priority, then there may be decrease of the term of such patent rights. And right for limited period of time, that is 20 years. No automatic relief. In case of such infringement, there is no any automatic relief. We have to file the suit. And before filing the suit, it is recommended we have to give notice to the infringer. And maintenance by renewal fee. Appointment of patent agent is not compulsory. Application can sign by the applicant themselves, but it is not recommended. We have 80% discount being a small entities like MSME, startup or individuals. And there are free professional services with patent facilitator. So such a registered startup have to pay only government fee. And under MSME scheme, there is a huge reimbursement of such IP filings. So there is a scheme of SIPP, a Startup Intellectual Property Protection. And there are some TISC center, Vipo Technology and Innovation support centers, where any Indian can approach, whether it's an individual, whether a small entity, whether a large entity or academic institution, anyone can approach. This is an extension of SIPP scheme. Under MSME scheme, these are the reimbursement. It goes directly to the MSME, not the facilitator. And for educational institution, there is another scheme of Kapila, where they can claim government fees. And if they approach to the TISC, there is no need to pay any professional charges. So total cost is 0. Recently, we have done Vishwas Amendment of Provisions Bill 2022, where if someone who is not authorized to claim such patent rights, if are claiming such patent rights, then the fine is 1 lakh. Nowadays, under this bill, it is proposed that it extend up to 10 lakh, and in case of continuing claim, a further penalty of 1,000 for every day. Again, under section 122(1)(a), if any person refuse or fail to furnish to the central government where the invention has been used for the purpose of government, the penalty is 1 lakh, and in case of the continuing claim, a further penalty of 1,000 for every day. So many times might be applicant or the person is not aware about such provisions, they may be penalized. Further, under section 122(1)(b), if any person refuse or fail to furnish to the controller any information or statement which is required to furnish by under section 146, that is for data regarding working of patented invention, and the fine for the same is may be extended up to 10 lakh. And now under this bill, it is proposed that penalty for a sum equal to 1/2% of the total sale of the turnover or a sum equal to 5 crore, whichever is less. Under section 129, practice by non-registered patent agent, earlier the fine extended to 1 lakh and 5 lakh in case of subsequent offense. Nowadays, under this bill, proposed that 1 lakh and in case of continuing default, a further penalty of 1,000 for every day. We have draft amendment patent rule 2023. Still, it has to be finalized. So, if someone interested to surrender the patent, there is no any government fee. Government welcome such surrender without any charges. There are some changes in the format. There are different forms. Form 31 is newly introduced for filing an application to avail the grace period. Earlier, in some cases, there is no any grace period, and so we have to lose the patent applications where we have some interest, but unfortunately, we missed the deadline. So this is a great relief. Although there is a huge government fee for filing such a Form 31. So there are some schedules, there are some changes there. Form 27 every year, earlier we have to file. Now it is proposed that we have to furnish it every 3 years. So this is also a great relief. So far, although this is not an optional stage, this is a compulsory step, but many patentee hardly submit Form 27, and so far there is no any action taken. So also give an option to file one form in respect to multiple patent provided. Further, earlier we have to file Form 27 for each applications. Nowadays we have to file it as proposed. Under proposed, this may be submitted once every 3 years, and we can submit only one application for multiple applications. So if someone have patent portfolio, they can enjoy filing all such information under one application only. Patentee licensee have to disclose all the sought out detail in the form. It doesn't ask for country specific detail to be shared if the product is imported for other countries. So earlier we have to disclose in details how many countries you import such patented invention, etc. Now all such details is not required until controller required it particularly. Further, we have to deploy FER within 6 months from the date of such filing. The word 2 months from the date of issuance of shall be first statement of objections. It is proposed that we have to submit the reply to FER within 2 months. If needed, we can extend the time. So there is a Form 31, but we have to pay extra for taking advantage of extension of the time. The controller may, under subsection 2 of section 8, for the reason to be recorded in writing, direct the applicant to furnish a fresh statement and undertaking in Form 3 within 2 months from the date of such communication. Earlier, we have to submit Form 3 every 6 months if there is any foreign filing. Even if there is no any foreign filing, we have to submit it with nil information. Now,
so just giving a time check. Can we wrap up in a couple of minutes, please?
Sure. This is the last slide.
Oh, great. Thank you.
I think we can wind up. And if there is any question, please feel free to ask.
Thank you so much again. Like, knowing the wealth of information that you have, and again, hands-on experience, that you've been able to share such wonderful insights with us. So I'm going through the chat box. It seems like Vijay had answered quite a few number of queries, for the time that the questions came. But we can take a couple of questions. So if there's anyone, please write it in the chat box, or you can even unmute yourself and ask.
This is a very good platform, l2proindia.com. I recommend it. And even I'm one of the participants here.
Great. Thank you.
Great resource. I noted.
Thank you.
My question is,
sorry.
sir, my question is, patent is granted only when we have proof of concept?
Proof of concept by your working example, if any, or you have to convince it by first in writing. If it is not convincing, then there is a hearing schedule. We may appear in the hearing. Ultimately, there must not be an idea level. We have some prototype and it's working, so that, and if obviously fulfill the patentability criteria like novelty, inventiveness.
Just to answer the question from my side, this is Ajit here. To get a patent, you don't need to have a prototype ready. However, your concept has to be proven theoretically, and it should be a concept that is practically enforceable and implementable. So prototype is not at all necessary. However, controller have a right to demand for a prototype in case controller thinks that the claimed idea or claimed invention is not practically implementable. But it is at the
No any
discretion,
example so far.
and there is no example so far that controller have asked for prototype or they have denied a patent right just because there is no prototype made. Thank you.
Absolutely right.
I have a couple of questions. Can you hear me? To Mr. Vijay Kumar, Shri Pujay.
Vijay Kumar had to leave for another engagement, but you can ask a question. And
The question is actually two questions I have. One is on the infringing and patentable. To understand it correctly, let's say there is a drug that has 10 compounds to manufacture, and I have found one of those 10 compounds a totally a different compound, which is, can that be an example of a patentable and infringing? Can I put the question again? If not,
What I understand, there are 10 components which is already in public, and you worked on one component that is different than existing component.
not no, no. Let's say there is a drug manufactured from 10 different chemical compounds, and somebody has taken a patent for that drug. Okay. Now, out of the 10 different compounds, I take a patent for a totally new compound, one compound which is totally new, and I take a patent. Now, can this be an example of infringing and patentable? Because I'm going to infringe on that product. I mean, I can't make that product, although I have taken a patent for one of those 10 compounds.
Sir, to answer your query, you have taken patent for one of the compound out of those 10 chemical components of a compound. Okay, so when you will apply for a patent, if you are applying as a for the whole compound, in that case also you will be granted the patent with the efficacy that is exhibited due to the your new chemical that is involved in that compound.
Okay.
So your compound composition will be unique in terms of the new chemical component that you have used, and you won't be infringing unless and until any of the family members has been already disclosed in the earlier patent application or earlier granted patent. Okay, so how and more of that. So the new chemical compound that you are claiming should not have the same characteristics as that of the compound that you are substituting from earlier 10 compound set. Otherwise, it will be considered as an infringement under doctrine of equivalence. Thank you.
That's what I'm saying. It will be infringing and patentable because it's totally a new compound, so it is patentable. But since the entire product consists of 10 different compounds that are already taken for that, it will be infringing on that product. That's what I just, in order to make it understood. I hope that is correct.
In one case, there are patented invention having 10 ingredients. In second invention, out of such 10 ingredients, there is single ingredients. I don't think product is same.
No, I'm saying I'm finding a totally different component, chemical, that functions, that can be substituted for one of those compounds, and the result would be the same. The efficacy of the drug, which was earlier there, if I replace it with a totally new compound, which I have discovered.
Product is same. Final product is same.
not the product, the result of the product will be same, the way it treats a certain illness.
So
Sir,
I'll clarify again.
Sir, can I
Uh,
clarify it? Sir, can I clarify it with your permission?
Yeah, sure.
Sir, you have to, when you are using this alternative component for that drug, you have to take permission from the original person who has done it.
So
Please
it's
take
infringing.
permission or you inform him that you are changing it.
That's what it's infringing in that case, right? That's what I'm saying.
No, you are not infringing. You have to take permission. If you are taking permission, it is not infringement.
If he doesn't give me permission,
Yes, they will give. It is already mentioned in the act also. Please see. If you are taking permission, writing black and white, no, it is not called infringement. You have to take
So,
permission
if
and tell
invention
him.
is different, then
Yes,
they need prior permission, and
yes.
there is no one who will give such permission if you approve.
Sir, we
Anyway,
are.
I
I'm
request,
telling you.
may I request your kind introduction from both Dr. Ruby and Mr. Ajit ji?
yeah, I'm a patent consultant, having industrial R&D experience of 10 plus years in semiconductor research and IP practicing experience of 12 plus years of experience. And I do consult R&Ds for their strategies and the white space along with general prosecution. Mostly I'm involved in strategies and advisory and infringement analysis cases. So in continuation, along with the introduction, I will clarify the doubt that was existing. As I mentioned, if the singular compound, that is a singular component that has been replaced in the compound, is not from the same family member as that of the earlier compound or having the same chemical structure, then the new compound will not infringe. Because when we will be proving efficacy, the reaction that is happening due to the new chemical compound, new chemical agent or a reagent that is introduced will have a different process of reaction. And that we have to establish. In that case, we will not be infringing. Otherwise, in view of the doctrine of equivalence, we will be infringing.
thank you.
What I'm saying. Recently, we have done it in
Excuse me.
Ayurveda. We replaced one component with tulsi leaves. And we have taken permission in writing. So we can do it. It is not infringement. Please take it in writing permission.
Sure.
Then
Ruby-ji, thank you for the advice. And Ajit, Rahul-ji, thanks for the logical explanation. So I hope this answers your query, but please do not treat any of this as legal advice because it's an open forum. Please, as the topic of this webinar says, do your due diligence for patents. So.
Thank you. And the other question, which is a simple question, is about the market due diligence. See, when he was talking, Mr. Vijay Kumar was talking about whether it has got a commercial potential, evaluate that. But let's say I have an idea, I have a product that I think in the years to come, it will find a market. Because let me give an example. Let's say I have discovered, I have invented a camera that can take pictures of the Earth, let's say at a very great height at which currently no object can fly. But let us say that expecting that the flying object can come a little later, maybe 10 years down the line. So in that case, the market due diligence, will it be correct to say that what it cannot have a commercial potential now, it may have in the future? So is it not a patentable in terms of due diligence? Because what he mentioned was that, if it has to have immediate commercial value, it may not. But in the long run, it may be. Many inventions are like that.
I don't think there is any problem, even if there is no any immediate utility. If we convince that there is a utility, there is a future utility, there are technology development, and there are many technology in future working on this concept, I don't think there is any problem.
Okay, thank you.
Is there any explicit provision for that, sir?
Okay,
No, I don't think so.
to Vaishal. Yeah, to answer the second question, I can give an example. I myself have worked on femto technology, which is the foundation of 5G in 2006, 2007. Okay. And 5G has been launched after 2016. So it is always possible that there can be an invention which will may not be able to come to market immediately, but if it has a commercial value, it is very much patentable. Thank you.
Any of the patent production will be for 20 years, right?
That will renew. And the date is count from the date of filing or the priority which given earlier.
Okay, so thank you. Thanks. I think that answers the query. I believe we've answered all the questions, and also we have extended past our scheduled time. It's almost 4:16. So, Pankaj ji and I know Vijay is not here, but we've had a consistent audience of more than 150 plus attendees. Very exciting and engaging discussions as the one we had. And as you can see, the questions that the attendee Vishali was asking that kind of represent the kind of queries that a lot of startups and MSMEs have. And these are all very natural questions that every patent filer must think about deeply before, okay, what is the kind of market that I'm trying to address? When will it develop? What are the kind of IP rights which I need? Patents are, of course, one very important IP right that we get, but please be mindful about other IP rights as well that could be a good part of your company. And overall, what we are encouraging startups and MSMEs to do is to have a quarterly IPR review, if not more often. Make it a good part of your business strategy so that it doesn't end up as a last minute question and you're left to react. Here you get a chance to strategize, get multiple opinions. We are very thankful to our experts today, Dr. Pankaj Kumar and Vijay Shivpuje. I mean, they delivered a fabulous session. And thank you to all the attendees. Uh, on a final note, I want to thank the ASSOCHAM team for a wonderful job in coordinating this, in getting all of us together. I wish you all a very happy afternoon and a pleasant rest of the day. Thank you all.
Thank you.